On December 1, 2016, the Utah Court of Appeals issued its decision in the case of Card v. Card. Here is the link to the complete written opinion, which is also included in the description section of this video report. In April of 2012, Marshall obtained a permanent protective order against Card. In April 2015, after the permanent protective order had been in effect for more than 2 years, Card moved to dismiss the protective order. Under Utah Code Section 78B-7-115, a protective order that has been in effect for at least 2 years may be dismissed if the court determines that the petitioner no longer has a reasonable fear of future abuse. Card argued that in determining whether Marshall no longer had a reasonable fear of future abuse, that the district court failed to apply the definition of abuse found in Utah Code Section 78B-7-102 sub 1. That defines abuse as, quote, intentionally or knowingly causing or attempting to cause a cohabitant physical harm or intentionally or knowingly placing a cohabitant in reasonable fear of imminent physical harm. Card contends that rather than applying the 6 statutory factors to determine whether Marshall has a reasonable fear of future, quote, physical harm, the court accepted Marshall's contention that, quote, a reasonable fear of future abuse, close quote, includes a reasonable fear of future, quote, domestic violence, end quote. A much broader term that includes the commission or attempt to commit harassment, mayhem, and stalking. The Court of Appeals disagreed. The district court correctly stated that in determining whether a petitioner has a reasonable fear of future abuse, Section 78B-7-115, quote, directs the court to consider a number of factors, including whether the protective order has been violated, claims of harassment, and any other factors that the court considers relevant, close quote. Although claims of physical harm and violence are relevant factors to be considered, the statute does not require the district court to find that physical harm has been threatened. In fact, the statute does not require the court to dismiss the protective order under any particular circumstance. Rather, if the court's decision is guided by the statutory factors, it has discretion to decide if and when to dismiss a protective order. Applying the factors from Section 78B-7-115 that were relevant to the case before it, the district court found that Card had violated the protective order and that he continued to engage in violations and provocative actions designed to harass and intimidate Marshall. It was abundantly clear from the district court's ruling that the court considered the relevant statutory factors in reaching its determination that the protective order should remain in place because Card had not demonstrated that Marshall no longer had a reasonable fear of future abuse. Significantly, the district court further found that Card had not demonstrated a change in his behavior from the time that the protective order was issued, and that he continued to justify the behavior that the court found to be threatening, intimidating, and harassing. Under these circumstances, the district court did not abuse its discretion in denying the motion to dismiss the protective order. Finally, Card claimed that the district court erred in imposing a sanction under Section 78B-7-115 sub 3. That section provides that the court shall enter sanctions if it determines that either party acted in bad faith or with intent to harass or intimidate either party. The district court made such a finding. Card did not demonstrate that the district court's finding was clearly erroneous, and thus the district court did not err in imposing a sanction.